Welcome to part two of Legal English Vocabulary for Courtroom. And in this one, we are going to talk about the remaining words which are very commonly used in the courtroom by the lawyers and the judges. So let's begin. Three phrases: sent to gallows, capital punishment, death sentence. They all mean execute by hanging. So whether you call it capital punishment, you call it death sentence, you call it sent to gallows, they all mean the same: execute by hanging. In some countries now, instead of hanging, they are choosing some other methods, but it is the most traditional way of executing. For example, finally the terrorist was sent to gallows. Next one is bring to book. So bring to book is basically to initiate some kind of inquiry, some kind of interrogation, to ask questions as a precursor of taking some action against that person. So when you want to bring someone to book, it means you want to ensure that some kind of punishment could be given to the guilty. The culprit must be brought to book. This is the sentence. It means that they should be interrogated, there should be a probe against them, and they should be finally given the punishment. I rest my case. This is another phrase, and it means that whatever you have just heard or said proves, support, or sums up the argument or point of view. So basically, when you say I rest my case, you want to say that I have presented everything from my side, summing up my opinion and my point of view. So that is, for example, a lawyer might say at the end of a legal presentation, I rest my case. Suo moto. So when basically suo moto is on its own motion. So when any authority takes up a matter without any involvement of any other party, then it is called a suo moto action. So, for example, um, a court itself starts discussing about a particular act or a new policy just because it thinks that it is of a larger public interest. So you can see the term is usually applied to actions by a judge taken without a prior motion or request from the parties. Means the judge himself takes up the matter because he or she thinks that it is in larger interest of the public or the nation. Next one is prima facie. Prima facie means at first time. Prima facie means at first sight or before closer inspection or something which is very obvious. That is prima facie. They had prima facie a legitimate complaint. Means in first view or at the first sight, it appears right, true, authentic, or adequate at first sight, ostensible and obvious. It was a prima facie evidence, for example. Indict. Indict means to charge with an offense, to criticize or accuse someone. He tends to indict everyone of plotting against his party. Now, we have already talked about accusing or alleging. So, what is the difference between allege and indict? Allege means an assertion, especially a kind of accusation or blame, and it may not have proofs, right? So, for example, if somebody alleges, it may not necessarily based on facts. It is just a blame or claim of something. While indict means to officially or formally accuse for some office. Means if in an office a person writes an application or a mail to HR department about certain issues he or she is facing because of someone else, then he is indicting. Someone or who initiates a suit in the court against something, then he is indicting the other person, the other party, the defendant. So indict is basically officially or formally accuse someone. Allege is accusing someone, but not may not be formally. For example, many a times opposition parties allege the government for something. So they may not have any formal forum for it, but when somebody goes in court or when somebody files a complaint somewhere at in a particular forum, then that person is indicting. Now, clemency, we have already seen this word in part one. Clemency is nothing but a disposition to show mercy, especially towards an offender, also known as mercy or pity, humanity, kindness. So when somebody moves a petition, petition we have already seen means a formal request. When somebody files a petition for clemency, it means the person is requesting, the person is asking for mercy. Next word is hereinafter. Many times it is used in documents, especially the legal documents, and it means in a subsequent part or from this point till the end of this document, it is applicable. Liable. Liable means someone who is legally obliged or responsible. So when I say the statement, he is liable to pay for damages, means he is legally responsible, means as per the law, he has to pay the pay for the damages, and then I can use he's liable to pay for damages. Null and void. Null and void means having no legal effect. So, for example, the previous order stands null and void. Mortgage. Mortgage is used as noun and verb both. And basically, when people mortgage, they basically give a pledge of specific property as security for a loan and its repayment. So let me take some more example. He mortgaged his property documents with the bank for a personal loan of 20 lakh rupees. Means he he gave his property document as a pledge so that he could get the personal loan from the bank. Okay, so mortgage. Warrant. Warrant is used as noun and verb both. So basically, warrant is a judicial writ. Writ we have already seen, a written order from the court. A judicial writ authorizing the search or seizure of property, arrest of a person, or the execution of a legal judgment. For example, the warrants were issued against Neerav Modi and Choksi. Summon. Summon is also used as noun and verb, and it means as a verb, it means to order to come and attend the court proceeding. So, for example, the court summoned the politician in that case. Means court ordered that politician to come and attend the court proceeding. As a noun, it is like the court sent a summon to that politician. Now, the next one is contempt. Contempt means willful disregard or showing disrespect to authority of court or legislation. So, for example, he was charged with contempt of court, right? Means a charge was levied against him that he actually showed contempt to the court order or court summon. Testify. Testify means basically to state or affirm as a testimony in a legal case, means when you want to say that yes, I have seen this and I verify that this happened, so you are testifying the statement. Evidence. Evidence is a thing or set of things helpful in forming conclusion or judgment. um, एविडेंस, जिसको हम सबूत भी कह सकते हैं. The broken window was evidence that a burglary had taken place. The adjective of this is evident. It is evident that this person committed a crime. So, evident here it means based on whatever proofs we have got. So, this has become obvious. Plead. Plead is a verb and it means to respond to a criminal charge. He pleaded not guilty. So if you see the plea, we have already seen plea is basically noun, and it is, if you remember, it is the defendant answer to the charges levied against him, and plead is verb. So he pleaded not guilty. Attorney. Attorney is a person who has been legally appointed or empowered to act for another. So many a times a person can hire an attorney who is going to attend the court case on behalf of that person. This person is known as attorney. The other simpler words are lawyer or solicitor. So with this, we have come to an end of this vocabulary for part 2. I request all the Vivian students to make a passage or a story based on the words told in part 2, and they should discuss it in the class. Thank you very much. Bye bye.